May I please, Your Lordship? I'd like to mention for a listing of a criminal appeal for the first time, my lord. The connected appeal is fixed for on 29th. My matter may be come up on 29th.
For admission.
Lordship.
Okay.
Obvious.
May it please, my lord. Lordship, I beg to mention item number 18 of today's list. 18. In this matter, Lordship, I am appearing on behalf of learned amicus N.K. Borua. He has already submitted his adjournment slip day before yesterday. So can this matter be taken up after 2 weeks, Lordship?
3 weeks.
2 weeks.
MS
MSP Dr.
P. Dotto, Learned Counsel, appearing on behalf of Mr. N.K. Borua, Learned amicus jury. Has sought listing of the appeal after 3 weeks. The mentioned memo to that effect has already been circulated. The consent of the learned counsel for the other sides. The praise allowed list the case appeal after 3 weeks on a date to be fixed by the office.
Obliged.
Daily list for motion item 1. Item number 2.
No, this is an appeal for conviction, RI for life.
Offense 302.
302.
Heard. Mr. R. Day. Learned counsel for the accused appellant. NMS Endas, learned additional public prosecutor for the respondent number 1, State of Assam. So this criminal appeal under section 374(2) Code of Criminal Procedure 1973 is directed against a judgment judgment and order dated 27/12/2023 passed by the Court of Learned Additional Sessions Judge, Bilasipara, Dhubri, in Sessions case number 40/2019, full stop, by the judgment and order dated so and so. The accused appellant, sole accused?
Sole accused.
The accused appellant has been convicted for the offense of murder under section 302, IPC, and he has been sentenced to undergo rigorous imprisonment for life and to pay a fine of rupees 10,000, in default of payment of fine, to undergo simple imprisonment for further 2 months. So the appeal is admitted for hearing. The case records of Sessions case number 40/2019 we call for issue notice returnable in 4 weeks. As MS Das, learned additional public prosecutor, has appeared and accepted notice on behalf of the respondent number 1, State of Assam. The issuance of formal notice is dispensed with. The learned counsel for the accused appellant shall have furnished an extra copy of the memo of appeal along with annexes to MS Das within 3 working days from today, and the accused appellant shall take steps for service of notice upon the respondent number 2 by registered post with AD as well as by legal process within 3 working days.
Item 3.
May it please. Appeal against conviction, Lordship. Sentenced to undergo life under
Heart,
section
Mr. Get along.
Osco.
Abhishek by informant. Office note dated 15/10/2020, as per office note. The respondent number 2, that's informant, has been served with the notice. Full stop. None has appeared to represent the respondent number 2, that's informant. Full stop. Amicus visible again. Video. White House. Sorry, amicus. Since nobody is representing, also,
Yes, Lordship.
your point. Uh, As the records, case records of the trial court have been received, the office to prepare paper book. This will prepare the paper book, release the case after 4 weeks, the report as regards the paper book.
Item 5.
Paper book is ready. Lordship, I have been appointed as amicus in this case. I have received the paper book, Lordship. They may be fixed for hearing as a Lordship.
Offense? Offense?
302, Lordship.
Okay. MS Das? Or- Yes. And MS N Das, learned additional public prosecutor for the respondent state of Assam. Full stop. As the paper book is made ready, the registry to list the appeal for hearing in the usual course.
Lordship. Date, Lordship.
Usual course. Oh.
Item 6.
Obliged, Lordship.
Yes. Ready? Everything ready?
Paper book is ready, my lord. I'll collect it.
Heard Mr. Endeka. Learned amicus curiae for the accused appellant, MS. And us. Learned additional public prosecutor for the respondent number 1, state of Assam. And
But I have
Mr.
to not-
Eknikor, learned counsel for the respondent number 2. Full stop. As the parties are represented and the paper book is ready, the registry to place the appeal. For hearing in the usual course. So the parties may
Well, I have not
Collect
collected the paper book, my
the
lord.
paper books from the registry, if not collected till date.
Item
Diplo.
7.
Yes, sir.
Paper book is ready, Lordship.
The learned amicus curiae for the accused appellant is found absent to the on call. Offense. Full stop. MS and us learned additional public prosecutor for the respondent number
302, Lordship.
state of Assam is in attendance. Prabhu Karnis. Karnis. To transfer creates. Is ready, the registry to list the appeal For hearing in the usual course.
No.
By the state. Yes,
May I please, Your Lordship? I am appearing as a legal aid counsel, my lord. Today they have served a copy of objection, my lord. Just now they have served.
you have been served.
Mm.
Okay.
Can I guess? And Sultana. Yes, Your Lordship.
Heard MS and Sultana. Learned counsel for the appellant and MS and thus learned public prosecutor. Additional public prosecutor for the respondent number 1, State of Assam. MS thus learned additional public prosecutor has submitted an objection to the application. Under section 389, CRBC will be filed during the course of the day. Post of- As sought for by the learned counsel for the parties, please the case after with the objection of the state on record.
Obliged.
Item 13.
May I please, Your Lordship? I'm appearing as the
Yes.
legal aid counsel in this case, sir.
Legal aid counsel.
Lordship,
File or objection, my lord.
File,
it has been filed, Lordship.
file.
No, I have some copy on him.
Yes.
I missed the item. He said that I preferred the objection. I have not checked the records, whether it's
For
the
the,
record. of-
IA, Lordship.
I
Yes.
just above. I no nothing. No objection.
No, file of sir.
No, Lordship.
No objection. This is file one, I think.
Oh, no, there is no.
He received way back on 29/9/2023. No, 29/9/2023.
What?
It was received by
Served
him.
upon me, Lordship.
Served upon. Lordship, after a week, I have missed the item in this.
The file perhaps. I lick it. MK Das learned legal aid counsel for the applicant and MSP Bhuyan learned senior counsel and additional public prosecutor for the opposite party number 1, State of Assam. What kind of offense? 302?
302, my lord.
MS Bhuyan has submitted that an objection on behalf of the state will be filed within a week's
Within
time.
Monday, it's ready, but I missed my file, my lord. It might be lying in my chamber.
Tell me.
After, within Monday.
Within Monday
Right.
or within a week from today. Please the case after a week.
Deep Lordship.
With
Item
the
14.
objection of the state, he filed in a meeting.
May I please, Your Lordship? As per office note,
14.
as per office
Yeah,
note, the learned counsel,
Applicant B. Mia.
Last time his name was not shown.
Appointed.
Mr. Ahmed's name was not shown.
Ahmed, okay, reflection of Ahmed name,
He's
okay.
appearing today.
yes. And may file objection in the meantime, okay. State file,
Yes.
so we have to hear,
And it was hard at like earlier. Is a question it was.
No.
how can it be hard?
It was hard, you know. It was making. That's actually. Councils are still so.
Yes, it used to be hard
No.
today,
Aji koriba.
one minute.
1 minute kutom nokoi. Emai kasa. Koriba na aji.
Do you want to file objection?
No, I mean, I cannot.
Okay, sorry.
That's fine. Yes, no problem.
Yes, approximately.
No, this is koriba. Koriba aji? Koriba. If she does the otherwise notice is duly served upon respondent number 2.
Yeah, please. Lordship. That matter, my lord, where there's eyewitness, not
Eyewitness.
PW1.
Wife,
PW1, my lord. Who alleges that her husband was killed by, my lord, the accused, my lord. And
Banstu language on Banstu. 1 minute, FIR, as per FIR, or date of incident is 23/4.
24/4.
Huh?
Oh, 23/4, my lord.
23/4.
Yes.
The FIR was lodged on the next day. FIR lordship will find at page
Hmm.
4.
Whether this GDNT 360 was exhibited.
GDNT 360, my lord.
Because after appearance of the appellant at Borghat Police Outpost
Yes, my lord.
at 6 p.m.,
My lord.
the GDNT 360
It is not exhibit.
dated 23/4/2014.
Yes, it doesn't appear to be an exhibit, my lord. Page 53.
Then accused was taken into custody.
My lord.
Superior authority was informed. Then the IO went to the place of occurrence. Then he found the body lying. Inquest was not done,
Not done.
but he visited the place of occurrence. Statements were recorded. Then X was produced.
My.
By the wife.
My.
And he sees the X. White seizure list exhibit 1. Drew the sketch map. Then brought the dead body to the police hospital. Next morning, conducted inquest. Then forwarded the dead body for postmortem examination. Where is the inquest?
Inquest page 63.
63. Then when postmortem?
Postmortem, your lordship will.
Page 56.
Exhibit
24/4, my lord, 12:10 p.m.
12?
12:10 p.m.
12:10 p.m. So all this happened prior to formal FIR.
Yes.
All this happened, so investigation was launched much prior to that.
Yes, ma'am. Just lodged. But then, my lord, there is a.
What will be the implication of this FIR?
Well, one person is saying, my lord, that though it's stated, my lord, the accused has surrendered. But, my lord, one of the witness says that he informed the police.
Huh?
One of the witness, he said that he informed the police. So whether the police acted upon the information of the accused, or the accused having surrendered, or it was started the behest of some information.
My query is,
Well,
all these things had happened
yes.
prior to the formal FIR at 11:30 a.m. on 24/4/2014.
My. On learning about the incident. Page.
Mr. Doctor, we like to clarify that we are of the view that your plea of alibi has no ground, because there was no question
Yes, ma'am. Understand.
against any of the prosecution witnesses. So there was presence,
Well,
which you did not confront.
my lord.
Regarding your absence, you did not confront any of the prosecution
My lord.
witnesses.
That is that.
You tacitly admitted your presence there.
I'll make a submission on that, my lord. But then, So far as my lord, the alibi is concerned, proof of alibi is concerned, that my lord, rightly rejectable. I will not argue on that matter. I will not argue on that matter. My lord, basic thrust of my argument would be, my lord, Lordship will see, my lord, first of all, I'll argue on 2 points. One is surrender, and first of all, Lordship, may kindly take up PW1, my lord, once again. PW1. Yes, my lord. Gaubura, my lord, he says page 15. My lord, I am the accused. This is the PW3. Lokhiram Kutum. Kutun. I know the accused is my co-villager. I'm the village head of the so-and-so village. Then, my lord, getting information, I immediately informed the police over phone and went to the place of occurrence. I saw the deceased lying on the veranda. I saw the injured so-and-so. Then, my lord, he says that when I was at the place of occurrence, the police came and seized the X in front of me. Then, my lord, PW 6. He is, my lord, one of the villager, my lord. He said that while I was returning home.
But anything substantiated by anything that is getting the information, I immediately inform the police station.
My lord, but then
Anything corroborative to that effect?
PW 6 is also saying the same thing. Page 21. Robert Horo informing my that brother who was
Which line you are reading?
my lord, about 3 lines from the top, my lord. PW 6. Robert Horo informed me that my brother so-and-so had killed my elder brother, Mato Horo. I came to our house and saw my brother Mato Horo lying dead in the courtyard. Then I called nearby people. At that time, it was about 6 p.m. After my call, some of the villagers came to the place of occurrence. Gaubura has informed the police matter to the police.
So it is after
Police
6.
But
It is after 6.
Time may not be that may not become consistent.
No, but still
About 6. This is about 6.
at
No.
about 6.
My lord. Now that particular.
At 6 o'clock,
My lord.
he called nearby people. After my call, some of the villagers came to the place of occurrence.
Yes.
Then Gabra has informed the matter
And police
to
came.
police. Police came.
So my lord, the Gaubura says I informed.
So it might be parallel.
It might be parallel.
His
Exactly, ma'am.
appearance before the police station
It might be parallel.
and also information by Gambura to police.
True, my lord. So therefore, my lord, whether this GD entry was not exhibited, number 1, my lord. Secondly, my lord, whether it was actually a surrender, my lord, that is because in the 313 statement, he denied that. Because that question also, in my humble submission, was not put properly, my lord. That ought to have been put in a separate bracket, my lord. That whether you surrendered. Lordship will find that.
Is there even? Is there even? Is there nothing? Then give
Question 11, my lord.
1 minute. It's the entry. And আৰু আপোনাৰ এই যে Caesar is 360. Reference to GD entry number 360. Though it was not exhibited, but from it transpires that investigation commenced on the basis of a GD entry.
My lord.
And we have seen the GD entry,
My lord.
though we cannot take into consideration in the judgment.
Right.
But this goes to show that this is there, and he made a specific mention, IO, in his chief as well as in the cross. So why we are asking you
My
that
lord.
this most of the investigation part
My lord.
commenced and completed prior to
That fact.
In some cases, even a period of a month or 10 days may not be a contributory factor of delayed FIR. But in some cases, even hours,
My lord.
then the question of some embellishment might be there. That is why
That's the, I'm not on that, my lord. I'm on, not even on the delay in the FIR, my lord. My lord,
no delay in the FIR means there is some implication. That is why
there's some implication, but in this case, my lord, I'm not, my lord, basically on that, my lord. Lordship will see, my lord, question number 11 that was put, my lord. Again, my lord, this question, he denies his, my lord, surrender, but then this question was not put framed properly, my lord. PW 11, Gopal Singha, page 34. 313 question, my lord. Gopal Singha had deposed that on 23/4/2014, he was serving as the ICO Borghat OP. On that day, about 6 p.m., you had appeared with the Borghat outpost and told the police that you had killed your brother Matoharo by assaulting him with an axe. Accordingly, GD entry number so-and-so was made and you were taken into custody. What do you say about it? I'm innocent. False case has been made against me.
no. How do you treat it?
My lord, my humble submission will be, my lord, this questions ought to be put in different parts, my lord. First of all, the question whether you have surrendered, because my lord, he is there before the police, my lord. And my lord, the question, my lord, would have been, my lord, ought to have been, my lord. No, he has answered, my lord. So he is denied. He says, it's a false case. It's a false case has been filed against me. Because this entire 3-4 questions were, my lord, facts were, my lord, put before him together. Innocent. And false case has been filed against me.
What he said about surrender? I
That's
did
what-
not surrender.
Exactly.
It is
my lord.
not his case.
No, my lord. Exactly, my lord. That's the
Mr.
point.
Dotto,
My lord.
it is not his case that I did not surrender.
My lord, that's the point I'm trying to raise, my lord. The question ought to have been, my lord, did you surrender, my lord? That question ought to have ended there.
No, in 313.
330, exactly, my lord.
Mr.
313, you cannot, my lord.
Incriminating circumstances testified by the witnesses
My lord.
are to be put to him. So that is why PW 11, what he said,
Exactly.
was put to him.
Exactly, my lord.
Right.
No, my lord.
And PW 11 says that you surrender
Yes.
before so and so. Why he was not answering specifically to it?
Exactly, my lord. Here, that's what I'm saying, my lord.
See,
The question is more than one, my lord. It has been only confined to that.
show me. It is prejudiced. Show me any authority.
I'll show me. I'll have my lord.
Show
It
me.
cannot be, bundle of facts cannot be put together.
Let us come.
Sentence তিনটা হচ্ছে ফ্যাক্টরি একেবারে
এখন Checkup. Her husband started Kajia. Why you did not cook meat? Then they were arguing. Then this appellant came here. Then they started, argument started between the appellant and the deceased. Thereafter, the deceased picked up the axe. Okay. Right. Then, in the meantime, scuffle. Then, in the heat of the moment, this man took the axe, snatched, and gave a blow. This is the story of the informant before lodging of the formal FIR in 161 at the place of occurrence in presence of all other witnesses. Right? But, oh.
Calling from a lordship matter.
No,
That's a
that is
lot-
okay. Just what is
Yes.
there.
Now, lordship, therefore, lordship looks at the evidence of the PW1. What transpires, my lord, this accused, even for assuming, let's for a moment that he was there, my lord. The accused, when he came here, my lord, he did not come with the intention of killing anyone. He was not carrying any weapon, first of all. And my lord, secondly, even after entering also, he did not pick up the axe. So it happened sometimes, something happened in between, as your lordship has pointed out from the 161 statement. That perhaps might be the correct version. So it was not with an intention of killing that he came. First of all, he came, nor he had any intention to kill anyone at that point of time when the scuffle took place. Because if the version of the PW1 is taken into account, she says that he came and assaulted me. Then the scuffle took place between me and my husband.
One more.
Man.
That to that part, informant is not very truthful. Look at the FIR.
Well,
What she said. Accused tried to
assault me.
Right.
Yes.
Now, how she improved in her before court?
Right.
Accused assaulted me. So, and what was which cannot be taken into account, 161 recorded prior to FIR. There was no assault.
No assault. No assault.
Directly in between the brothers,
Right.
she tried to persuade them.
Yes.
That is 161. So, step by step,
There's an improvement. In fact,
so at least we can take note of this FIR and her testimony that FIR said tried to assault. In her evidence, assaulted, but resulting in no injury.
no injury.
So that part is bit doubtful. Then if the remaining part, what we are discussing, that all culpable homicides are not murder. All murders are culpable homicide. So first we have to find out whether it is culpable homicide. Then we have to find out whether first, second, third, fourth of 302 will comes in or not. Even if it comes in, whether the murder falls in any of the 5 exceptions. I think.
Well, true, man. Because here, that's what I'm saying.
So going here and there will not
Not.
Serving.
So, my lord, when he came in, my lord, basically, he did not carry any weapon, first of all. He did not pick up the weapon at the initial stage also. As per the evidence of PW1 is very clear. Even though she has tried to improve. She even also tried to say that he also threatened to kill me also. So therefore, it would be suggesting that she was trying to implicate him in the murder. Because if he had the axe in his hand, he had given one blow to the husband, the deceased. She could have given another blow to the deceased and fled away from the scene. She said that, first of all, as your lordship had pointed out, at the fire, she said that he tried to assault me. Then here, she said he assaulted her. And then he said that accused also told me that he would kill me after coming out of the jail after 3 months. So this is where she is trying to improve upon the incident.
Yes.
Now, as your lordship will find, my lord, even if her evidence is to be believed, nowhere, my lord, it can be found that the accused came with the intention of killing, or that intention was formed even, my lord, after entering the house. It happened much after. She says, the scuffle took place between between my husband and my brother-in-law. I tried to dissuade them. Then the accused took the axe in his hand, which was kept outside. So he perhaps again, as per her version, she went back and put up the thing. Then the accused came inside and assaulted my husband by striking with an axe. The accused told me that he would also kill me after coming out of jail after 3 months. So she was trying to improve upon the case, my lord. Now, in a cross-examination, my lord, in her evidence, my lord, she was totally silent about her quarrel between the husband with her husband, my lord. It is only in a cross-examination, my lord, she says, after I was cooking food after coming from hospital, then my husband came and assaulted me in anger for not cooking meat. The houses of the accused, my brother-in-law, are adjacent. When my husband assaulted me, I cried loudly. Hearing my cries, 2 persons came in. They are Sunil and Rajan. Now, we do not know who this Sunil is. If Rajan is the other Rajan Horo, who has deposed, my lord, he says he was not there in the place of incident. Now, the police, my lord, did not even try to, my lord, find out who this Sunil is. Or whether they were there, my lord. Nothing is done there, my lord. At that time, my brother-in-law came to my house crossing the concrete wall of my campus. At that time, I was crying. So her story has a lot of inconsistencies there. And as your lordship has seen, my lord, there are marked improvements in trying to implicate the, my lord, accused person in this particular with this particular offense, my lord. So, well, had he had the intention of killing, my lord, he could have, if he also hadn't come with the weapon, my lord, could have picked it up from the, my lord.
But are you trying to bring it out of the purview of section 300?
No, my lord,
Like I
not
said.
my lord. I would like to, my lord, say, my lord, of course, I'm trying to say, my lord, that this incident, my lord, so far as the evidence is concerned, my lord, it is not at all, my lord, reliable, number one. And secondly, or even if it's not fully reliable, my lord, and there is no corroboration, my lord, there is nothing to link, my lord, my lord, X with the, my lord, accused, my lord. No FSL examination was done. The fact that even he had hit her, my lord, there was nothing to indicate, my lord, that he was the person who committed the crime, my lord. Because the other 2 evidences are saying, my lord, the wife and husband and wife also had the habit of, my lord, fighting and, my lord, with, my lord, lathis and all. So she might be totally lying, my lord. She might have used the X, my lord. Because her, my lord, statement, my lord, that he had also threatened that she would kill her, my lord. That shows, my lord, she was trying to say more, my lord, something more than, my lord, what actually was, my lord, what happened, my lord. She was deliberately trying to, my lord, implicate this, my lord, the, my lord, accused person. Therefore, my lord, without any corroboration of her statement, my lord, she is not a reliable witness, man. And all these hypotheses are open, my lord. It cannot be said, my lord, that this had happened, my lord, with beyond reasonable doubt, man. She also admits that there's no enmity between her brother-in-law, and my lord, and husband. Though they are not in talking terms, there's no enmity as such. So there is no motive at all also, my lord, to my lord, kill, my lord, the deceased person.
Maybe there may be some contradiction here and there, but her version on material point that her husband was killed by the accused remains unrebutted throughout her cross-examination.
That's why I'm saying, my lord, in a cross-examination, my lord, she had developed the story further, my lord. If she had, my lord, said what she had omitted. In the cross-examination, my lord, in her evidence, my lord, she was totally silent about her altercation with the husband, my lord. It is only in the cross-examination, my lord, she admitted, my lord, that the husband she had a quarrel with the husband, my lord. And that may be very relevant in this context, my lord. Because, my lord, the fact remains, my lord, the burden, my lord, is to prove the offense, my lord, is on the prosecution, my lord, beyond all reasonable doubt. And here, as I'm, my lord, humbly submitting, my lord, there are all hypotheses open, my lord, all possibilities open. And therefore, my lord, to rely solely on this, my lord, witness, my lord, without any corroboration, my lord, even the weapon not being linked, my lord, with the offense, my lord, or rather, my lord, the accused. And my lord, PW8 and my lord, PW7. Both of them, my lord, indicated, my lord, that the relationship was, my lord, not good at all, my lord. Number one, between the husband and the wife. And PW7 specifically said that once she had used the lathi against, my lord, her husband, my lord.
But PW, informant himself said, we have no bad relation. Though there is no coming and going between the two families, the informant says,
Yes, ma'am. She said, don't get. So therefore, there's no motive attributed also. Well, that's the reason, ma'am. She is trying to create, well, that's the reason I'm saying, well, though there's no motive to show, well, why he will kill her. At the same time, she is trying to implicate him, my lord, for some reason, my lord, which is because, my lord, she's trying to say that she also threatened to kill me, my lord. He could have killed her immediately, my lord. And
no, Mr. Doctor, we have to find out whether there was intention to cause murder or intention to inflict a bodily injury. Out of that situation.
true, my lord.
And if the bodily injury is such that which is likely to result in death, despite no intention,
Well,
his presence, I don't think, can be doubted.
but even assuming, my lord, his presence was there, my lord. Whether he was a catalyst actually in the, my lord, whether he was even trying to, my lord, settle the issues, that's another issue, my lord. Because PW1 per se, my lord, there is a lot of loose ends in her story, my lord. He might have been there to save his brother.
No, propagating many theories will not do.
No, but then
You propagate one theory.
no, it's true, because well, I'm
Here
trying to
and
look at
there
the
will
scenario.
not do.
I understand. my lord.
Whatever you have to submit, it has to emerge from the evidence on record,
True, my lord.
right? Because whatever you have done during the trial has an effect
True, my lord. That
during
is,
the appeal,
that is true. My lord.
right?
That is.
How the trend of your cross-examination, right? Theories may be propagated,
No.
but those theories are to be connected with the defense you have taken
Exactly, my lord.
during the entire course of the trial. These theories you have never taken.
Well, one of course is there, my lord.
That might be wanted to save his brother. The wife might have assaulted her husband.
My lord.
These theories are not there.
This is not, but then one part is there.
This
One-
don't bring imagination
My lord,
here.
one part is there, my lord, that that suggestion was given. That in the quarrel, he picked up.
We'll see about your trend of cross-examination.
My lord, I'll come to that. That also.
We'll only concentrate.
My lord.
Otherwise, no submission
My lord.
on that aspect. Whatever your trend of examination,
My lord.
cross-examination of the prosecution. That's all. তো কিহৰ কাৰণে দিছিলো পাহৰিলো নহয় এতিয়া।
Any witness or ইত্যাদি
অ
fully reliable, partly
Oh.
reliable.
Who is response number 2? Mother.
Mother, my lord. She said she came afterwards, my lord. But so far as the cross-examination is concerned, my lord, one suggestion was put, my lord, which she denied. Page 11
Which one?
of the PW1, page 11, my lord, that cross-examination, my lord. It is not a fact that my husband took the X and when he tried to snatch the X, my husband got injured. So that is what 161 statement reflected, my lord, that the husband took up the X, my lord. And
That remained a suggestion.
that was suggestion.
That remained as a suggestion.
My lord. Yes. My lord, therefore, my lord, what happened, my lord, the lordship looks at the evidence of PW1. My humble submission, my lord, this is not fully reliable evidence, my lord, number one. And under those circumstances, my lord, even a suggestion was also put, my lord, that husband took up the ex, my lord, and there was a my lord scuffle in between all the three of them, my lord, and someone had, my lord, killed, my lord, and used the ex, my lord. So, my lord, and my lord, nothing has been done, my lord, to link the ex with the, my lord, the accused also. Nothing has been done to link the, examination of the ex was made. No FSL examination was made. Nothing has been done to even link, my lord, the ex with the accused person. So therefore, these circumstances, my lord, when your lordship looks at, my lord, the evidence of PW1, my lord, which apparently, my lord, is suffering from serious contradictions, my lord, and embellishments, my lord. And the fact remains, my lord, that she was in chief. She had totally, my lord, silent about the fact, my lord, that they was having a quarrel on that day. In the cross examination, of course, my lord, it was elicited from her that her husband had assaulted her. So there was already some kind of, my lord, assault going on when this incident took place. And as your lordship would find, my lord, from her evidence also, my lord, that he did not carry the weapon in his hand. Even, my lord, he did not pick up the weapon after entering the area. It's only later on perhaps the weapon came into the picture. So all this, my lord, creates a, my lord, kind of a, my lord, doubt, my lord, as to whether, my lord, 302 would be, my lord, can be, my lord, sustained against him, my lord. There's apparently, my lord, something amiss in the story, my lord, which the PW1, my lord, would have shed light into. She did not. Therefore, my lord, her evidence is not, my lord, though it's she is a, my lord, eyewitness, my lord, her sole testimony is not, my lord, cannot be the, my lord, basis of conviction, my lord, under 302, my lord, in my humble submission. The facts of the case, my lord, has to be, my lord, seen, my lord, in totality, my lord. Yes.
Lordship, in order to draw a conclusion whether the learned trial court was justified in convicting the accused appellant or not, Lordship had to rely on the evidence of PW1. If your Lordship, the evidence of PW1 sustains, then your Lordship may be pleased to uphold the conviction. Lordship, the PW1, who happens to be the eyewitness to the occurrence, although she is related to the victim. Lordship, whether her testimony is believable, my lord. Lordship, may I once again take your lordship to the evidence of PW1, my lord? Yapi Horo. I'll read it slowly, your lordship. I know the accused, page 10. The accused is my brother-in-law. Deceased Matohoro was my husband. Around 2-3 p.m. one day, about 8 months ago, the incident took place. I was at home on that day. That day, I was at home after getting my health checkup done. I was cooking food at home. My husband told me that he would eat meat. I told him that if I did not get fish, I would bring meat. At that time, the accused came to our house and assaulted me. Then a scuffle took place between my husband and my brother-in-law. I tried to dissuade them. Then the accused took the axe in his hand, which was kept outside. Then the accused came inside and assaulted to death my husband by striking with the axe. The accused told me that he would also kill me after coming, after 3 months. My husband was killed in the kitchen itself. He assaulted my husband on his head and his head got cracked. The accused went to the police station after killing my husband. At about 8 p.m., the police came. The police took away the dead body of my husband as well as axe. I have seen the axe in the court today. The accused killed my husband with the axe. When the seizure list was prepared, I put my thumb impression therein. I gave the axe to the police. In the morning, next day, I lodged an Azahar with the police station. I put my thumb impression in the Azahar. The Azahar was written for me as per my words. Police prepared inquest report on the next day on the dead body. On the day of lodging the Azahar, and I put my thumb impression therein. There was no enmity between my husband and brother-in-law, and we did not have visiting terms. I was cooking food after coming from the hospital, and then my husband came and assaulted me in anger for not cooking meat. The houses of the accused, that is my brother-in-law, and ours are adjacent. When my husband assaulted me, I cried loudly. I cried loud. Hearing my cry, 2 persons came. They are Sunil and Rajan. At that time, my brother-in-law came to my house crossing the concrete wall of my campus. At that time, I was crying. I lodged an Azahar on the next day, but the police came on the night of the incident before lodging the Azahar. The police examined me on the following day. It is not a fact that I did not state to police that the accused assaulted me. The axe I saw in court today was ours. It is not a fact that my husband took the axe and that when we three tried to snatch the axe, my husband got injured. It is not a fact that the accused did not treat me. After 3 months, he would kill me after coming out. It is not a fact that I had enmity with the accused, and for that reason, I have given a false statement in the court today to implicate the accused. Here, the presence of the accused person is well proved. If 2 hypotheses, my lord, hearing he went cry, that the victim assaulted while he was assaulting the informant. That time after hearing he went cry, he came over. It may be a hypothesis, my lord, or your lordship. The other story, my lord. In examination, which they stated, accused took the axe in his hand, which was kept outside. Accused came inside and assaulted to death my husband by striking with the axe. But the presence of accused persons was there, my lord. And lordship, whether the case can be brought in under the exception, my lord, may I submit to your lordship, since it was dealt on the vital part of the body of the victim, as a result of which the victim died instantaneously, my lord. Lordship, whether your lordship will bring it under general exception, that your lordship will judge. I've got a judgment, but here eyewitnesses are there. Only one, there are eyewitnesses, but since it was on a vital part of the body, court did not give that benefit.
What is the legal proposition, established legal proposition?
Lordship,
Since time immemorial,
it may be brought in, my lord.
1860 Penal Code, culpable homicide,
Amounting to murder,
299,
my
300.
lordship,
Culpable homicide defined,
lordship.
then 300, unless falling in the exception.
My lord.
Culpable homicide is murder if any of the following
Conditions are full.
4 categories or
Yes.
5 categories. Then it is murder. Then again, one has to proceed further.
Three.
Whether murder falls within any of the exceptions.
So if your lordship wants to grant that benefit, exception one can be brought in, my lord. Exception one.
No, that grave and sudden provocation has to be given to the accused.
May
Exception
not,
one.
may not be, my lord. Let us see, my lord.
Perhaps.
Lordship,
Exception one.
yes, my lord. Last line explanation.
Hmm?
Lordship, may I read it once? When culpable homicide is not murder, culpable homicide is not murder if the offender, whilst deprived of the power of self-control by grave and sudden provocation, causes the death of the person who gave the provocation or causes the death of any other person by mistake or accident. The above exception is subject to following provisos. That the provocation is not sought or voluntarily provoked by the offender as an excuse for killing or doing harm to any person. That the provocation is not given by anything done in obedience to the law or a public servant, it's not material. The provocation is not given by anything done in the lawful exercise, it will not come, my lord. Given enough to prevent offense. Right. Whether the provocation was grave and sudden enough to prevent the offense from amounting to murder is a question of fact.
No, where is the evidence as on provocation?
Lordship, since she may, she was, if your lordship assumes, my lord, that because of the assault given by the victim to PW1, as she made hue and cry, lordship,
Hmm.
he,
Provocation is to somebody else. Or what?
as a result of which the accused person arrived at the spot after hearing hue and cry and he got provoked.
Hmm. Provocation is to be to him or to anybody else also will apply.
I think it will apply, my lord.
Provocation to put over there. Hmm?
Except so normal.
No, he will.
Lordship, illustration may I read, my lord?
Hmm.
A, under the influence of a passion, excited by provocation given by J, intentionally kills Y, J's child. This is murder, inasmuch as the provocation was not given by the child and the death of the child was not caused by the accident or misfortune in doing an act caused by the provocation. Exception for it has been elaborated, my lord. Culpable homicide is not murder if it is committed without premeditation in a sudden fight, in the heat of passion, upon a sudden quarrel and without the offender having taken undue advantage or acted in a cruel or unusual manner. Explanation: it is immaterial in such cases which party offers a provocation or commits the first assault. Regarding the altercation, my lord, she has also stated in her FIR, my lord.
So there was one blow perhaps.
Yes, so the case I'll be citing case of single blow, but it was in a vital part of the body. In the event of the matter, Honorable Court upheld the conviction under 302. But there,
C, illustration C,
Restriction C. Lordship?
murder.
Yes. Murder. A by shooting at a foul. That one, my lord. A by shooting at a foul with intent to kill and steal it kills
No,
B.
A intentionally gives
Which one, my lord?
under 300.
Under 300. Illustration C.
Hmm.
A intentionally gives Z a sword cut or club wound sufficient to cause death of a man in an ordinary course of nature. Z dies in consequence. Here, A is guilty of murder, although he may not have intent to cause death.
Okay, it is murder.
My lord,
Even if there is no intention to kill.
kill.
But the bodily injury, if sufficient to cause death, it is murder. Then thereafter, we have to find out whether it falls under any of the exceptions. Only possibility is either exception 1 or exception 4.
4. My lord.
Given certain provocation, I think, I don't know, it is to be given to the person, he has to be provoked.
No, my lord,
But exception 4.
Exception
So
4,
picking up the axe from the courtyard,
yes,
which is a normal instrument present everywhere in a village house. That is one. Because he crossed the boundary without equipping himself with any weapon of assault. Then he initially proceeded to
like settlement,
argument
Yes.
with his elder brother.
yes,
And might be the argument going on with his wife might be the trigger. So he crossed the boundary without equipping himself with any weapon of assault. Then involved in an argument with his elder brother. Then if we assume that as said by the informant, that he went outside and picked up the
whatever he has got,
axe, which the disease kept there,
yes,
picked up, made
but it
an
wasn't a vital
assault,
part.
right? Bro, but question is vital part. So it is illustration C, no doubt.
My lord,
Murder,
My lord,
but exception 4, without premeditation,
that is there, my lord.
in a sudden fight,
Hmm.
in a heat of passion,
passion,
on a sudden quarrel, and without the offender having either taken undue advantage or acted in a cruel and unusual manner. Had he made 3-4 blows, it would have been quite.
Lordship, that play I leave it to your lordship because it wasn't a vital part of the body and
Because
he died instantaneously, my lord.
I am looking at the classic. What is classic locus? Vivian Bose. Explanation by Honorable Justice Vivian Bose in Virsa Singh, which is time tested till now.
Lordship.
That first you have to examine culpable homicide, and you have to examine whether it falls under murder. Then again you have to go to the next stage, that whether it falls under
Under any of the
any
general
of the
exception.
exception. Then again it comes back to culpable homicide amounting to murder.
Murder.
First culpable homicide, then culpable homicide amounting to murder, then any of the exceptions, it again comes back to,
Culpable homicide.
but that is 304 part 1,
Lordship,
not part 2.
but not part.
I think that is. We'll start.
May not be required. Citation.
One more. Virsa Singh has been retried or not? First, tell
Let's
me.
see.
About
Dukes.
Virsa Singh retried or not?
I'm not sure, my lord. No, your lordship.
Hmm?
Um,
Anything?
And credibility of single eyewitness.
Same solitary.
We'll start
Lordship.
whatever time is available. बाकी जाओ and others may go. Others may go. Others may go.
Well, I'll just one place one judgment, my lord. It's on, my lord, that reliability of witness, my lord. That is, my lord, 1993 3 SCC 282, Anil Fukan versus Citizen.
Anil Pugar was relied on in one of the cases.
We'll go by Vadi Velu Thevar, where every judgment follows Vadi Velu Thevar. That was what both of us were looking at. That is followed in the judgment you have relied on.
Right.
Everywhere. But Vadi Velu was relied on.
Vadi Velu, just check
Vadi Velu Thevar.
Just check it out. No, perhaps not, my lord.
19 AR 1957. Supreme Court.
No, my lord, not relied upon.
614.
Not relied upon.
The instant criminal appeal from jail is preferred against a judgment an order dated 17/7/2019. Passed by the Court of Learned Additional Sessions Judge, Sunitpur at Tejpur. In Sessions Case number 165 of 2014. Full stop. By the judgment and order dated 17/7/2019, the Court of Learned Additional Sessions Judge, Sunitpur, Tejpur, within bracket the trial court, has convicted the accused appellant for the offense of murder under section 302, Indian Penal Code. And as a consequence, the accused appellant has been sentenced to undergo imprisonment for life and to pay a fine of rupees 5,000, in default of payment of fine, to undergo rigorous imprisonment for another 3 months. Full stop. In addition, the accused appellant has also been convicted for the offense under section 448, IPC, and for the offense under section for finding him guilty for the offense under section 448 IPC, the accused appellant has been sentenced to undergo rigorous imprisonment for 6 months. Full stop. Both the substantive sentences of imprisonments are ordered to run concurrently. Full stop. Para. We have heard Mr. M. Dr. Learned amicus curiae for the accused appellant, and MS B.S. B. Bhuiya, Learned Senior Counsel and Additional Public Prosecutor, Assam, assisted by MS R. Das, Learned Counsel for the respondent, State of Assam. Full stop. The case, sessions case number 165. Repeat no koro apni chako. Section case number पे क्या हुआ 165/2014, arose out of Tejpur Police Station, case number 464/2014, and ZR case number 936/2014. Full stop. Para. The crime case, Tejpur Police Station, case number 464/2014, came to be registered on 24/4/2024, 04/2014. Pursuant to lodging of a first information report by the informant, comma, MS Yapi, YAPPI, Horo, comma, wife of late Mato, MATO, Mato Horo, on 24/04/2014. Before the in charge, comma, Borghat outpost under Tezpur police station. Post of on receipt of the affair, comma, the in charge, Borghat outpost. After registering the same as Borghat outpost general diary entry number 370, dated 24/04/2014, comma, forwarded the affair to the officer in charge, Tezpur police station, for registering the case under proper sections of law. Post of at the same time, comma, the investigation of the case was taken up by the in charge Borghat police station. Post of on receipt of the affair, command officer in charge, Tezpur police station, registered the affair as Tezpur police station case number 464/2014 under section 302, comma, IPC. Post of para. In the FIR, comma, the informant had inter alia stated that when in the afternoon on 23/04/2014, an altercation was going on between her husband, comma, Mato Horo, and herself over a domestic matter in the afternoon, comma, likhuwa at about 4 p.m., comma, on 23/04, huh? The accused who was her brother-in-law, comma, trespassed into their house at first. House, post of. At first, but it was alleged that at first, comma, the accused tried to assault her. When the accused tried to assault her, her husband tried to resist the accused. Full stop. At that time, comma, the accused picked up an axe, comma, which her husband kept in the courtyard after cutting firewood, and assaulted her husband by striking a blow with the axe. Full stop. According to an informant, comma, her husband died instantaneously and the accused fled from the place of occurrence. Full stop. Para. After investigating into the case, the investigating officer of the case, upon completion of investigation, had succeeded a charge sheet under section 173 2 CRPC. White charge sheet number 214 of 2014, dated 23/5/2014, finding a prima facie case for the offense under section 302, IPC established against the accused appellant. Full stop. On submission of the charge sheet, the court of goodbye to the there's the court of learned so and so. The appearance of the accused appellant, court of additional chief judicial magistrate, that's page 4, who was taken into custody on the date of incident, that is 23/4/2014, from jail custody on 17/7/2014. As the copies were ready, the same were furnished to the accused as per the provisions of section 207 CRPC. Finding the offense under section 302, IPC exclusively triable by the Court of Sessions, the Court of Learned Additional Chief Judicial Magistrate, Tejpur, by an order of commitment dated 17/7/2014, committed the case records of ZR case number so and so to the Court of Sessions for trial. The learned public prosecutor was notified accordingly. And the accused person was directed to be produced before the Court of Sessions on 31/7/2014. Para on appearance of the learned, on appearance of the accused before the Court of Sessions. On receipt of the case records of GR case number so and so, the Court of Sessions, Sunitpur, registered the same as Sessions case number so and so, and forwarded the case records to the Court of Learned Additional Sessions Judge, Sunitpur, Tezpur, within bracket trial court. Here I got trial court na lage. For disposal. Upon appearance of the accused before the learned trial court and after hearing the learned public prosecutor and the learned counsel for the defense, the the following charges were framed against the accused. Page 7, paper book 1, 2, task. When the charges were explained, explained and read over and explained to the accused, he pleaded not guilty and claimed to be tried. During the course of the trial, the prosecution side examined 11 number of witnesses and exhibited, exhibited 6 number of documents and 1 material exhibit to bring home the charges against the accused person. Page 53. So the prosecution witnesses who were examined by the prosecution were 1, 2, 3, 4, 5, 11, and the documents exhibited were 1 to 6. Page 53. An X was exhibited as material exhibit number 1. Post up. After closure of the prosecution witnesses, the accused was examined under section 313 CRPC. Post up. When the accused was asked as to whether he would reduce defense evidence, the accused answered in the affirmative. Post up. In his defense, the accused adduced evidence of 1 defense witness, DW1. Post up. After appreciation of the evidence materials on record, and after hearing the learned counsel for the parties, the learned trial court has convicted the accused for the offenses, mentioned above, and the accused has been sentenced in the manner indicated above. Full stop. Para. Mr. Dr. Learned amicus curie, appearing for the appellant, has submitted that other than the autopsy doctor and the eye of the case, the prosecution side had examined 9 number of witnesses, who narrated about the alleged incident. Full stop. Out of those 9 number of witnesses, none had deposed as eyewitnesses, except the informant, PW1. Full stop. Narrowing on PW1, Mr. Dotto has submitted that the narrowing on informant as PW1. Mr. Dotto has submitted that even her testimony does not inspire confidence. Full stop. Though it is not open to base a conviction on the testimony of a single witness, but such testimony has to be trustworthy and consistent. Full stop. But in the case in hand, the testimony of the informant as PW1 as an eyewitness does not are fraught with inconsistencies, and as such, her testimony is cannot be relied upon. Full stop. And what is next? What is next?
Well, so far the surrender is concerned, well, that is also well, doubtful because there are evidences. And 313 question was not
The-
properly made.
IO of the case, PW
PW11.
11 deposed that the accused had surrendered at the police station on 23/4/2014. Full stop. Such, but the said witness, that is PW11, did not exhibit the concerned general diary entry to support such fact. Full stop. Moreover, the accused in his examination under section 313 CRPC had clearly denied about any act of surrender on his part. Full stop. Since the testimony of the sole eyewitness is not reliable and does not deserve credence, the accused deserves to be acquitted. In such view of the matter, submitted that the judgment and order of conviction and sentence passed by the learned trial court is liable to be set aside, and the accused is deserved to be acquitted of the charges. Full stop. Para. MS Mia, learned additional public prosecutor, opposing the submissions, contentions of the learned amicus curiae, has contended that the learned trial court, after proper appreciation of the entire evidence of materials on record, has correctly arrived at findings, had arrived at correct findings in respect of both the charges. Full stop. The informant as PW1 was an eyewitness to the entire incident and except 1/2, O1E stroke TW2 inconsistencies on trivial matters, comma, her testimony is found to be consistent throughout. Full stop. Further, comma, her testimony is also corroborated by the medical evidence, which, full stop, the MS Bhuya has contended that the medical evidence clearly indicates that the accused had inflicted the blow on the vital part of the vital part on the head of the vital part on the person of the disease, comma, that is on the head, and the injury was such that it would lead to death. Full stop. MS Bhuya has referred to the postmortem examination report, comma, EXT2 to buttress such submissions. Full stop. It is thus contended that there is no question of interference with the judgment and order of conviction and sentence passed against the accused, and the present criminal appeal is devoid of any merits. Post of para, we have given our consideration to the submissions, rival submissions of the Learned Council for the parties. And I have also perused the evidence materials available in the case records of sessions, case number so and so, comma, in original. Also, we have also considered the citations, decisions cited by the Learned Council for the parties. Tuesday. We'll keep it on Tuesday.
Lordship, yes, regarding the surrendering part, it was not put to the accused person. Question number 11, my lord, regarding surrendering.
He is extensively referred.
I've referred. What I'm saying is that that question ought to have been put in a different, smaller question.
The content was put.
Content was put, but there was, since more than one fact was put, created some kind of a confusion, might have created some confusion.
Two.
This was not, Thevar was not specifically reliable. That is the sum and substance of that also.
নাই ন এইখন এইটো
My lord, I beg to mention item number 2.
What do you want?
The time before the timing, adjourn the matter.
Timing is not possible.
Adjourn the matter for today.
Case they received, Lordship.
Yes, they received. On interim. Okay, we'll wait for some time.
Lordship,
Wait for
retain
some
the,
time. What for, hardly 2 matters.
Lordship.
Yes, let us take up the first one. Yes, why this is listed?
Lot because it's pertaining to the same FRI.
Okay, produce the case diary.
Lordship.
Lordship, just I wanted to point out that on a same ground, Lordship, FIR
Mr.
is
Bora,
copy
let us
paste
have the case diary.
13 days, Lordship.
Okay, we'll be sitting on Friday, no? Single. Friday, single bohim, no? Friday, Dr. Sarapur, no? Huh? Friday? Heard Mr. BP Bora. We'll be sitting on single on Friday.
31st of May.
No. At 3 o'clock. Okay. BP Bora. Accused petitioner, MS A. Begum, Land Additional Public Prosecutor for the Respondent State of Assam. This is an application under 439. লিখে দিব। Release the case on so and so for production of the concerned case diary. Yes. Yes, what is there?
Lordship, she have recorded her statement, Lordship. And she have stated that, Lordship, the money they have taken, Lordship, but the main director, Lordship, Pulin Soy, they were the employees. The petitioner is the employee of that bank, Lordship.
Hmm.
Pulin Soy, he left off contacting with the employees too, Lordship. There were some 8 employees, Lordship.
Hmm.
Among them, one is C, Lordship. She went under 41A also, and she have recorded her statement under 161, Lordship.
Okay.
The
Who is your
statement,
senior?
My lordship, P. Dotto,
Your name?
S. Arafat,
SR?
S. Arafat, Sahir Arafat.
Fahir Arafat.
the statement she have recorded, Lordship, it is reflected as 240324. But the interim is granted on
34.
34. That means it was 41A in there, but after getting the interim, they have not appeared, I think, because it's not in their
Okay.
statement is after interim.
Yes, there is up to?
Up to, Lordship, 25, 2024.
25.
Because the director, Lordship, who was arrested, as he have not recorded his statement, he was on interim, but he have not recorded his statement within the period of time. Then he was arrested on 18/5. Now he is behind the jail, behind the bar.
Why you are not then?
And your
Lordship.
statement is also after interim, their statement is also not there, Lordship. So may I call for up-to-date status report whether she have recorded her statement or not?
Hmm.
But she have appeared the police station, Lordship, for 41A
Okay, prior to interim.
prior to interim.
After interim, whether she
No, it's not in the case. diary.
recorded her appearance.
No, that is not in the case. Diary. Only 24/4/2024 is there, Lordship, her statement.
Mr. Dotto is available or not?
No, my lord. He is out of station, my lord.
We can grant 7 days time.
Lordship, within that period, they will record it.
Hmm.
Till then, I'll bring up to
Okay,
the
we'll put him in his
Hmm.
permission.
Lordship.
I heard Mr.
Arafat.
S. Arabha.
Arafat.
Arafat. Appearing for the petitioner and MS A. Begum, learned additional public prosecutor for the respondent state of Assam. First of Mr. Arab, learned counsel for the petitioner, has submitted that the petitioner has been granted interim protection on 34/2024 with a direction to appear before the IO of the case within a period of 10 days from 34/2024. Post of para MS Begum, learned additional public prosecutor who has received the case that has submitted that the petitioner or perhaps appeared before the IO subsequent to 34/2024. Post of Mr. Arafat Peraha, learned counsel for the petitioner has submitted that he will obtain instruction as regards appearance of the petitioner before the IO of the case subsequent to 34/2024 in terms of the order dated 34/2024. Post of he has further submitted that the petition be granted liberty granted liberty to appear before the IO within a period of 7 days from today. Obtain instruction again. We granted a liberty, to appear before the IO of the case within 7 days from today, if she has not appeared due to reasons beyond her control.
Lordship.
Post of such liberty, as paid for by the land council for the petitioner, is allowed. Post of release the case on
Lordship on June, Lordship, then we'll bring the up-to-date case there. We'll return the CDL.
Miss
June
Miss
12th.
Begum has so and so has sought for listing of the case on which date?
12th of June, Lordship.
12th of June, in order to produce an up-to-date case diary. So release the case accordingly on 12/6/2024. The interim order past shall continue
Nice.
till the next establishment. But you appear, otherwise we'll recall the interim order.
Yes. Obliged.